The Supreme Court this Monday has ruled that a Washington State public school district violated the rights of a high school football coach who was Christian and who was suspended for refusing to stop leading prayers with players on the field after games. Broadening the religious rights of government employees, the justices sided with Joseph Kennedy, who until 2015 served as a part-time assistant football coach in the city of Bremerton and has since become a cause célèbre for conservative Christian activists. The court's conservative justices were in the majority in the 6-3 ruling, its Liberal members dissenting. Let's get some comment on this highly politicised and religious role it seems the Supreme Court is playing. Ian Reifowitz joins us, author of The Tribalisation of Politics. He's Professor of History at Empire State College at the State University of New York. Ian, pleasure to have you with us. Is the Supreme Court overstepping in the name of religion?
Well, it certainly looks that way. There is a very clear tradition in American jurisprudence going back to certainly to the middle of the 20th century that government officials are not allowed to essentially use their positions to promote a particular religion or religion in general. And I think today's case is another example where we're seeing that. You have even if he's not a paid employee, even if he's a volunteer assistant coach, he's still acting in his capacity as a representative of the school on the field at the end of the game, leading a prayer. That's something that until today was not acceptable, or we assumed was not acceptable in the United States because of the First Amendment and the policy, the Constitution's language on separating church and state. Now we have a new opinion on that. Certainly, the opinion on abortion derives, at least in part, from the religious, the belief of people who practice religion in a certain way that life begins at conception rather than at some other point in the process of pregnancy or birth. Other religions disagree. So again, we have a particular religious belief being privileged. So yes, I think you can say that religion, certainly thanks to this Supreme Court, has been given a more prominent role in terms of government endorsement of religion than we had only 1 week ago.
You mentioned, of course, the Supreme Court justices, the conservative ones who were recently elected, who said, I think at the time, and correct me if I'm wrong, that they wouldn't let their religious feelings interfere in any decision on Roe versus Wade. Now that appears to be exactly the opposite. It must raise more questions about people's belief in the basically objectivity of the Supreme Court.
Well, sure. I think you're right, Mark. The decision doesn't necessarily, the decision on the overturning of Roe v. Wade doesn't necessarily say we are doing this because the Bible tells us so. They're not saying that. But look, they're not fools, and they would never. They would, if they had said that would have been a controversy far greater than the one we have right now. But it's clear that we have a court that is acting in a way that no court has acted before. There has never been a right identified by the Supreme Court of the United States as being a constitutional right, and then have another court take that right back. It's never happened in the history of the United States. It's happened now. So when a right is recognized and then reaffirmed, as it was recognized in Roe versus Wade and then reaffirmed in Casey versus Planned Parenthood 19 years later, it's a super precedent, so to speak. That was irrelevant for this court. They overturned it. Why? Because they had the votes to do so. I think what we have now is a court that's acting, or that sees itself as having the authority to act much like the president, with having a veto over legislation or over previous court decisions that it doesn't agree with. That's something that is going to continue the process of undercutting the court's legitimacy among Americans, which was at a new low according to a Gallup poll last week that came out before this decision, which has again already been polled and is significantly underwater with the American.
If I'm right, 25% I think was the level of faith that Americans have in the Supreme Court, according to that poll, which it strikes me as a layman as completely shocking. And what you're saying, it sounds like the Supreme Court is really playing fast or loose with the Constitution right now.
Well, that's an opinion. It's one that I share. But the Constitution is essentially whatever the people in charge interpret it to be, who have a majority to issue that opinion. And right now, that's a Supreme Court majority that has the ability to do what it's doing, just like Mitch McConnell had the ability, if you want to look at it that way, to prevent Barack Obama's nominee from the Supreme Court, Merrick Garland at the time in 2016, from receiving a hearing. That doesn't mean it's constitutional in any objective sense. But I guess their position is that those who have the power and have the power to enact the provisions that they see as constitutional, and consequences will be what they will be.
Ian Reifowitz, as ever, thank you very much for joining us. Always a pleasure speaking to you. And thank you for throwing some light on these stories, which, of course, many people are concerned about right now. People are protesting about it too. And as we've heard, the state of Louisiana, things being put on hold there regarding the abortion ban by that legal challenge mounted by one of the three women's clinics in that state. Ian, thank you very much indeed for being with us.